inability to tax, raise an army, enforce legislation, and regulate interstate trade. The decision to hash the articles resolved these issues by establishing congressional power in Article 1, Section 8, and executive in Article 2, and judicial powers in Article 3 of the Constitution.
The first state constitutions introduced reforms guiding the framers in establishing our federal constitution. The 1776 Virginia Constitution contained a Declaration of Rights serving as a necessary check to restrain all branches of government. Brutus II argued, ought not a government vested with such extensive and indefinite authority be restricted by a Declaration of Rights? If state governments thought it necessary to have a Bill of Rights preside over their state constitutions, why not the federal one? Virginia's constitution also provided for a bicameral legislature, governor, and judicial system, the roots of our federal government today.
In 1780, Massachusetts delegates were elected to frame a constitution and submit it for popular ratification. This planted a new seed of government. The democratic principle of the Massachusetts Constitution fit the emerging theory of popular sovereignty, the same principle of our preamble. We the people do ordain and establish this Constitution of the United States of America. In almost every state, unbalanced government and legislative supremacy prevailed, but not in Massachusetts. Massachusetts became the first state to give more than lip service to separation of powers, establishing the precedent for a strong, popularly elected executive with veto power under Part 2, Chapter 1.
Jacob and I agree. The Supreme Court functions as a continuing constitutional convention because decisions can devise alterations or provisions necessary to render the federal constitution adequate. A court decision may compel significant action not previously realized by the state or national government.
In the 1920s, Supreme Court decisions expanded portions of the Bill of Rights, incorporating amendments to the state level. Gillow versus New York, the first of these landmark selective incorporation cases, held that the 14th Amendment of the United States Constitution extends the First Amendment's provisions on freedom of speech and freedom of the press to the states.
Kian and I disagree that the Supreme Court is a continuing constitutional convention on the basis that Article 3 states all cases that arise under this Constitution. The courts cannot decide cases without a direct challenge. Without laws and action taken by the states or federal government, the courts would have nothing to decide, much like the 1786 Annapolis Convention. Only laws by Congress and state legislatures mark the new Cambrian growth rings in a living constitution. Thank you.
Perfect timing. Wow. All right, thank you. I guess I need to go back to the very beginning because you discussed the fact that those 12 delegations that went to Philadelphia ignored the instructions. How about the one state that did not go? Shouldn't their decision not to go have acted as a veto since unanimous consent was required for amending the articles?
No, it shouldn't have, because in Federalist 40, James Madison states in Federalist 40 that the benefit and the fate of 12 states should not depend on the corruption of a 13th.
Along with that, Federalist 2 argues that the people had reason to confide in the people of this Congress because they had grown old in political information and they were distinguished by their virtues of patriotism and their love for their country. And so although Rhode Island was not there, there was good reason to put the faith in the people of this Congress because they were there to make the Union a better situation for themselves.
And although what they did might have been illegal, it was not illegitimate because the ratification of the Constitution was ultimately ratified by state conventions and by the people. Article 7 entails that it shall be ratified by the conventions of 9 states. And I think that's very important because the Constitution is written for us, the people.
Thank you.
Following up on that comment about the Constitution is written for the people, and the Supreme Court having a kind of a restricted role in writing new Constitution is sort of not appropriate. But which branch would be close to a ongoing, enduring convention? Would it be the legislative branch or the executive branch?
The legislative branch would be closer to an ongoing constitutional convention, because even in the convention, the framers thought it would be like this. They opposed the adding of a trial by jury in civil cases in the Constitution because they thought that Congress, by statute, could provide for this right in appropriate cases.
However, all the branches working together functions as a constitutional convention because the legislature brings the ideas to the table. It creates legislation, laws, and bills to put forth. And then the executive is sort of like the vote at the convention. It decides, hey, this is for the good of the nation, or hey, this is not. And then the Supreme Court acts as the ratification. It decides whether a law is ultimately constitutional or not.
Along with this, you can see this level of combining the branches to work as a constitutional convention in the case Prince versus the United States, where the legislature brought the Brady Handgun Protection Act to the states and wondering if this would be a good legislative idea. And the Supreme Court struck this down, saying that the necessary and proper clause could not create this law, and that this would be a commandeering part of this law.
Okay, so some of you believe that the Supreme Court acting alone acts as a constitutional convention, and others of you think that all the branches acting together play that role. Then I'm just wondering, is Article 5 superfluous? Did we not need any provision for amending the Constitution?
I don't think so. I think Judge Learned Hand argues in a spirit of liberty speech that liberty lies in the hearts of men and women. And so I think in order to best protect our liberties, we need to rely on our elected representatives, not an independent body of judges like we do much of today.
Additionally, Article 5 is not superfluous because sometimes Supreme Court decisions need to be overturned by an amendment. For example, the 16th Amendment, the poll tax, was put in place because of a decision of the Supreme Court called Pollock versus Farmers Loan and Trust.
Also, in Federalist 62, James Madison argues that Article 5 is there because without it, it would render the Constitution too mutable. And this can be seen in the case Oregon versus Mitchell, and where 18-year-olds states did not have to allow 18-year-olds to vote based off because they were not discriminating against anybody, but this was brought in by the 26th Amendment to allow 18-year-olds to vote.
So you gave several examples of states that contributed positively to the Constitution. Were there any state constitutional provisions or any really raggedy ones that you saw that said good thing it didn't show up?
In Federalist 70, Alexander Hamilton pointed to numerous examples of states where an executive was too mutable and too weak because there were too many people at the top. He argues that unity is conducive to energy and that executive must have energy, but in almost every state except New York and Massachusetts, this power was not being granted.
Additionally, in the Georgia State Constitution, every oath of office is followed by "So help me God," which is, may I continue?
Yes.
Which we decided to strictly avoid in our own Constitution. And this was only added later by precedent through George Washington swearing in on a Bible and saying, "So help me God."
Thank you. Very good. So a few things that I would like to share with you. And one is, I really was impressed. That's the big one that I want to say. There was quite a bit, and I think, so that I don't take up all the time and I leave some for my colleagues, the third part of the question, the part that talks about the Supreme Court as a continuing constitutional convention, I don't know how you answer that one way or the other. I mean, I think I have a very definite opinion, but the fact that you chose to say, well, you know, a couple of us look at it one way, a couple look at it another way, you know, it would have been nice if I made you pin yourself down to one, but I really appreciated that you did that because there are multiple sides to that question. So I'm going to let it go at that. Very good job.
Thank you.
Thank you.
I'd like to echo the comments of my colleague, Mr. Draper. It was a good analogies, good works. It started strongly and it had some beautiful words that flowed beautifully together, and that makes it enticing and interesting. I very much appreciated your response. You know, for example, with what Mr. Draper said, is this Supreme Court thing is very tempting to get into a big old long discussion about that. And the way you set it up was, there's a lot to talk about. We'll do it if you wanna, but you're gonna have to make us, you know? So that gave us the opportunity to talk about something else. Well, if it's not the Supreme Court, then what other pieces are there? And that gave at least in my impression, it gave me an opportunity to ask a more complicated question that allowed you to elaborate and synthesize the powers and interactions of the different branches. And that makes it a more plausible connection to the people directly. And because I think an extension of this conversation could turn into what left the Philadelphia Convention was 7 articles, and it left needing to be fixed. So it was better than what they came in with. And that again is another discussion. So the fact that you prompt all this stuff is what is indicative of a good, solid We the People team, is that we would love to have more time with you to talk about more of this, but thank you very much for the work that you did.
Thank you.
Thank you.
Yeah, I'm going to reiterate and reinforce what my colleagues have already said. It is indicative of a good team when you are really just chomping at the bit when the time goes up, because you have other questions that you want to pursue. And that was definitely the case with this team. You had a very provocative, interesting opening statement, and you also were able to draw out a lot of those themes. One thing that I wanted to say about the opening statement is that you both had the sort of thematic cohesiveness that drew all of these disparate parts into one cohesive argument, but at the same time providing a great deal of diversity, and to be able to do both of those together was very impressive. And also in the Q&A, you again were able to look at multifaceted different ways of the answers, and you had done such a thorough job talking about how the Constitution was amended through the Supreme Court and the other branches. I thought I had a gotcha question by asking you about Article 5, but you really came back swinging on that question. Well, I thought you fielded that question really well. So I just want to say, overall, really strong round. Nice job, guys.
Thank you.
Judges, I just want to say thank you for taking the time to do this and really give these students this experience, because, you know, after things get canceled,